it's our pleasure to host this GDPR workshop and welcome everyone today, especially to our lovely clients. We've got some in the room and quite a few on the webinar, so morning to you guys. Thanks for joining us. Can I give you a brief introduction to Stephen and I and the corporate team and what we do here? We work across a lot of really vibrant and exciting sectors in Scotland at the moment: technology, innovation and life sciences, healthcare, food and drink, media, to name just a few. We're always busy advising our clients in a vast range of commercial and corporate matters, from private equity investments to spin-outs, from acquisitions to sales, share option agreements, preferred suppliers, T's and C's, and lots more in between. The one thing we've probably all got in common, and I know you probably don't think you've got anything in common with lawyers, and I don't blame you for that, but it's personal data. We all hold personal data in some form. From the smallest sole trader to the biggest PLCs, all of our businesses capture it, and almost on a daily basis for many. Your business will probably hold personal data about customers, suppliers, contractors, paid or unpaid staff, interns, volunteers, a whole raft. And it is estimated by the International Association of Privacy Professionals and EY that Fortune's Global 500 companies will spend roughly $7.8 billion in order to ensure that they comply with GDPR. With the effective date of the 25th of May 2018 fast approaching, it is becoming an important priority for businesses to get prepared. Going forward, and in very simple terms, businesses will need to be able to show that they have looked at all of their data, that they are working on minimising the risk of any personal data being leaked, and that all analysis of that personal data is legitimate and justifiable under GDPR. So, we hope that you find the workshop informative and thought-provoking. We do understand that it's a lot to take on, and there will be some parts that are relevant and some not so relevant to your own businesses and situations, but the aim is to get you thinking about how GDPR is going to affect you and your business. Whether your business obtains personal data direct from a data subject, which you want to be able to transfer or share with others, so you would be a data controller, or whether your business is a service provider, which obtains personal data from a data controller and uses that data to deliver its services, so you would be a data processor. Or maybe you might have a business that does both. You might obtain personal data and share it with a processor who also shares personal data they have with you. So the arrangement is more of a mutual sharing, where both businesses would have both data controller and data processor obligations. We'll go into these roles in more detail later in the presentation. However, I thought it would be helpful to go over the basics very quickly. So what is data protection? Data protection is defined as legal control over access to and use of data stored on computers. What is GDPR? If you don't know by now, we'd be very surprised. It's the General Data Protection Regulation, and it is a single set of rules applicable across the EU. Because it's a regulation and not a directive, it automatically applies in the UK. However, the UK is also going to enact a Data Protection Act too. What is personal data? So personal data is any information related to a natural person or data subject that can be used to directly or indirectly identify the person. It can be anything from a name, a photo, an email address, bank details, posts on social networking sites, medical information, or a computer IP address. It can be electronic or paper-based. Sensitive personal data is data consisting of racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership, genetic data, biometric data, data concerning health, or data concerning a natural person's sex life or sexual orientation. I think we might have some businesses joining us today who collect and process sensitive data. The ground for processing sensitive data under GDPR broadly replicates what the rules under the DPA, but they have become slightly narrower. Any processing of sensitive data must satisfy one of a number of conditions. However, I suspect the main condition which our clients will use is the explicit consent of the data subject. So, where might the relevant information sit within your businesses? We've already covered examples of the types of entities and individuals whose business you might hold. That was your contractors, your suppliers, your paid staff, unpaid staff, volunteers. And these are the main areas where personal data is likely to be held across your business. So you've got operations, HR, records and information management, IT, marketing, finance, web design, product development, and compliance. So why do we need GDPR? There are two main reasons for it. First is insufficient current legislation. So GDPR is a major change in legislation since the 1998 Data Protection Act. The Data Protection Act was the cornerstone of UK data protection law. However, in the late 1990s, there was no cloud, no social media, no social networking, no tablets, no smartphones, no apps. Amazon and eBay were very, very young startups, so it was a very different picture to today's technology-driven world of call centres, data storage clouds, and apps. With changes in technology over the last 20 years, most are of the view that current law is outdated and not as relevant as it could be, and that tech development has overridden the rights and freedoms of individuals. The second reason is to strengthen data protection for individuals. Irrespective of the B word, Brexit, the UK has no choice but to comply with EU regulations. Many say it's about time individuals had more control over how their personal data is used. And the EU wants to give businesses a simpler, clearer legal environment in which to operate, making data protection law identical throughout the single market. And the EU estimates that it will save businesses a collective €2.3 billion per year. GDPR will enforce strict controls in respect of data processing with a whole new approach. The burden of proof will rest with you guys, the businesses, the companies, to show the governing body
Should I really book you next time that you can hear me?
that you've made an effort to review the data,
Is that really book you? Can you hear that?
process,
Is that annoying you that you can
and
hear me? No,
show you have appropriate contracts
You didn't
in place that clearly state what you're doing with personal data, and that you have appropriate activity, logs, and records. So who does what? I mentioned earlier data controllers and data processors. Data controllers are the natural or legal person, public authority, agency, or another body which alone or jointly with others determines the purposes and means of the processing of personal data. So an example of a controller would be a bank. It collects the personal data of its clients when they open an account. Data processor means any person other than the employee of the data controller who processes the data on behalf of the data controller. Examples of processing can be amending, altering, sharing, transferring, deleting, storing. These are all types of processing. And an example of a processor would be a payroll company, a firm of accountants, market research companies. So both data controllers and data processors need to have a thorough understanding of the new obligations under the forthcoming GDPR, given the expected impact it's going to have on business operations. So the starting point for data controllers is to audit any and all current contracts and agreements with data processors. And this might require a little bit of renegotiation. In particular, check that your agreements require the data processor to process personal data only in accordance with documented instructions from the data controller. It should ensure that any and all personnel of the data processor involved processing the information have appropriate confidentiality obligations in place. You need to ensure that they have an appropriate technical and organisational security setup in place too to guard against unauthorised or unlawful processing. You want to ensure that the data processor notifies the data controller without undue delay upon becoming aware of any personal data breach or circumstances that might give rise to a breach, and to report that within 72 hours. You want them to cooperate with the data controller and mitigate any personal breach. You want them to maintain a record of what they're processing, and at the end, you want them to delete or return all the data to the data controller at the end of the term. Processors should check that agreements require the data controller to provide details of the nature and the purpose of the personal data to be processed. You want the data controller to provide a warranty or a guarantee or promise to the data processor that the data controller has obtained any and all consent of the data subjects required in order to commence the processing. You want them to agree precisely what categories of personal data are to be included, and whether that includes the sensitive data that we talked about earlier. You want them to agree to permit the international transfers of personal data if it's necessary. And you want them to ensure that if any personal data of any data subject out with the European Economic Area, that proper obligations are in place in respect of that. And ultimately, if there's any fine levied against the data controller and the data processor, only the portion for which the data processor is strictly liable should apply to it. Finally, we've got the Information Commissioner, and that is Elizabeth Denham. She's the ICO in the UK, and she has set out a commitment to increase consumer trust that people have in what happens to their personal data. So that forms the basis of her strategic plan, and that's been demonstrated in her commitment to ensuring companies are transparent with the public about how personal information is used, most notably with high-profile investigations into companies like Yahoo, Camelot, WhatsApp and Facebook. And Ms Denham also oversaw the ICO's largest fine being issued. It was a penalty of £400,000 to TalkTalk after the telecoms company failed to properly protect customer data from a cyber attack. So who does GDPR affect? Well, I think we've figured out today that pretty much everybody, most businesses, companies processing or holding personal data of data subjects residing in the EU, regardless of your location. So let's consider a couple of scenarios. Data transfer from the UK to a data processor in one of the two of the following, either in the UK, EU or European Economic Area, or a non-EU country. The 1998 Act applies at present, but in the future these transfers of data will be governed by GDPR and our new Data Protection Act that's coming in. Their provisions impose particular restrictions and requirements. The requirements have to be met by the data controller if it is to transfer the data lawfully. So in that first scenario where the data processor is in the UK, EU or European Economic Area, the current legislation requires there to be a written contract under which the data processor agrees to act only on the instructions of the data controller. The GDPR also states the contract must contain details of the processing to be carried out and details of the data processor's obligations. So if you're using any such contracts and they don't contain GDPR requirements, you'll need to replace them or amend them before May 2018. And we can of course help you with that, and we can help you put in place appropriate and GDPR compliant data processing agreements. As for the second example, where a data controller in the UK is sharing or transferring data to a data processor out with the EU, under current legislation you are prohibited from doing that unless the destination country has adequate levels of protection for the rights and freedoms of the individuals concerned. There are a few approaches to try to achieve that adequate level of protection. The first approach is called recognised destination, and if the country is recognised by the EU Commission, it satisfies the test, and there's a list of those countries on the Commission's website. The US is slightly more complicated. It's not on that list, but transfers are permitted if the US recipient or data importer has self-certified compliance with the Privacy Shield framework. The recognised destination will continue under GDPR. A second approach for adequate level of protection, so that's if the country isn't on that recognised destination list. You can try and meet certain specified adequacy criteria, and you'll be glad to hear I'm not going into any of these today, and they are of limited use and pretty tough to satisfy. And finally, the third approach are exemptions, which will remain mostly in place under GDPR, and examples of them are things like substantial public interest of the UK, so that's crime prevention and in connection with legal proceedings. We would always recommend that clients achieve compliance by using model terms, and these are published by the EU Commission. So, moving on to employers and employees. Are employers, if you're an employer and you're in the room or joining us in the webinar, are you doing enough? The message from GDPR is all about accountability and being able to demonstrate compliance with GDPR and the awareness of the rights of employees. You need to ask, what personal data do you hold? Can you minimise what you hold? And do you hold more than you need to hold? We'll learn more about individuals' increased rights from Stephen shortly. However, in terms of employees, under the GDPR, employees as data subjects do have greater rights. So the upshot of this for UK employers is they're very similar to the DPA, but the downside is the GDPR slightly expands the rights under the DPA, introduces a few new ones, and imposes significant penalties for breaches. Under the GDPR, employees as data subjects have the following rights. So they have the right to be informed, the right of access to information, the right to rectification of data that's inaccurate, the right to be forgotten, the right to block or suppress processing of personal data, and a new right of data portability, which allows employees to obtain and reuse their personal data for their own purposes across different services under certain circumstances. So, if you are an employer, there's very different employers around, there's very different businesses facing very many different challenges depending on your sector, your space, your size, your global reach. Your businesses will all vary in the number of staff, and maybe your businesses won't even have staff, maybe they have self-employed contractors. Either way, all employers face new challenges. For example, ENR companies, which are energy and natural resources companies, they've got global reach. They send staff all over the world to work, sometimes in pretty far-flung locations out with the EU, and the companies must ensure that that personal data of those individuals is kept secure and confidential. Global businesses also face a challenge at more local levels, where data privacy standards on the ground are not quite aligned with GDPR. The companies need to work on encouraging accountability, even in those areas of the world, in order to help avoid any possible breach. So what do you need to do? You need to notify employees, workers and contractors about the personal data you hold about them, how they can expect that data to be used, and for what purposes their data will be used. Because employees have a right to a copy of all information held about them. For that reason, we would recommend having in place the following templates. An employee subject access request form template, and also a template for an acknowledgement of that subject access request on company letterhead. There are a couple of versions of that acknowledgement. There's a standard version and there's a more complex request. The standard version response acknowledges the request from the employee and might request some formal ID in order to process the request. Slightly more complex requests can sometimes take more time and involve more internal processes for the employer to obtain information, for example, going through lots of emails or big documents. And therefore, the employer can acknowledge the request, but also explain that the standard response timescale of 1 month might need to be extended. Additionally, you as employers may want to consider appointing a DPO, which is a Data Protection Officer, to focus on ensuring compliance with GDPR. It's only strictly required if you're a big public authority or carrying out large-scale monitoring or processing criminal convictions information, but some businesses are choosing to appoint someone to take responsibility and take the lead. On the reverse, if you're sitting here as an employee, You need to be aware that there are possible consequences if you do not comply with new privacy regulations. Examples of the types of offences an employee may commit would be to destroy information or records after a subject access request has been made, to re-identify de-identified data, or to obtain, disclose or procure disclosure without consent of a data controller. And the possible repercussions for this would be one of two things: potentially disciplinary proceedings or possible termination of employment. I wanted to give you an example of this type of scenario, and it was the case of Robert Morrissey, who was employed by Rochdale Connections Trust. Morrissey sent spreadsheets containing the information of vulnerable clients to his personal email address without the knowledge of his data controller, his employer, Rochdale Connections Trust. Morrissey sent 11 emails from his work email account in 2017, which contained the sensitive personal data of 183 people, 3 of whom were children. The personal data included full names, dates of birth, telephone numbers and medical information. So Morrissey appeared at court and he admitted unlawfully obtaining personal data in breach of Section 55 of the DPA, and he was given a conditional discharge for 2 years and was ordered to pay prosecution costs. What the head of enforcement at the ICO said, which is really good, was people have a right to expect that when they share their personal information with an organisation, it will be handled properly and legally. That is especially so when it is sensitive personal data. People whose job gives them access to this type of information need to realise that just because they can access it doesn't mean they should. They need to have a valid reason for doing so. Copying sensitive personal information without the necessary permission isn't a valid reason. So that brings us smoothly on to the up-and-coming data protection principles, of which there are 6, and I'll invite Stephen to talk us through those principles.
Thanks very much, Lucy. So, fair and lawful processing. Sorry about that, folks. So, we'll discuss here a few aspects. Fair and lawful, the process of consent is covered under this principle. We'll also look at what are the alternatives to consent, how you might think about your website and cookies, and also how you might approach any marketing issues. Okay, thanks. Right, I think we've sorted the IT now. So, what is consent to process? This will come in with effect from the 25th of May and the new GDPR becomes effective. So, consent must be freely given. So, that means there must be no imbalance of power. It must be a free choice of the data subject. The consent must also be specific, informed, and an unambiguous indication of an individual's wishes. So, specific, this is a granular interpretation. So, I consent to X, but I do not consent to Y. Effectively, consent shouldn't be sought on a blanket basis for all manner of purposes. It should be quite specific as to what people are consenting to. Consent must be informed, so a privacy statement or privacy policy should be available so that the subject can make an informed decision. It should be in clear language, and it should contain the identity of the data controller, so the data subject can make an informed decision about where their data is going. It must be unambiguous and by a statement or clear affirmative action. So a tick box where it's made clear what the tick is giving consent to. Pre-tick boxes mustn't be used. They shouldn't actually be used already, but I think there will be a sea change in terms of a lot of companies absolutely moving away from any pre-tick boxes, so make sure you do avoid that. The consent must signify agreement, so similar to the clear affirmative action. By doing A, the data subject consents to B happening. And also, I can change my mind or withdraw consent. So it must be straightforward. It must be explained how to actually withdraw consent. And one thing to definitely bear in mind, keep records of any consent you have obtained. Apparently, JD Wetherspoon's pubs deleted their entire email newsletter contact list, but I don't think they were sure how the actual consent had been obtained. They probably looked at it and thought that the task was too challenging to go back and really kind of work out what had gone on, so they decided just to clear the slate. I suppose the takeaway point from that might be if it's not clear how the data was obtained, you might need to take steps to rectify it. So, what if consent isn't suitable for processing? What are the alternatives? An example might be if the relationship was imbalanced between, say, employer and employee, you might need to look elsewhere to lawfully process the data. So as an overall point here, the interest in processing must be legitimate, so using it for a legitimate purpose makes sense. Other options you could use is the processing must be necessary to perform the contract. So, for example, if you're a delivery firm, they'll need to know your customer's address to enable you to deliver the goods. Processing necessary for the performance of a public task, so perhaps imposition of a parking fine or some other offence, someone's unlikely to consent to that, so you need to be able to process their data accordingly. For compliance with a legal obligation, so if the data controller is legally obliged to do certain things, using the data, then that may be permitted. And also to protect the vital interests of a data subject, so maybe healthcare, some form of police or security matter might be a means by which you can process the data. I think time would preclude us from going through this in a huge amount of detail, but if you don't have consent, you'll need to consider if some form of necessity could be relied upon. It's worth noting that the Information Commissioner, who Lucy mentioned earlier, the website is a really good resource for all things GDPR. Website is ico.gov.uk. It's ico.gov.uk. Sets out a whole load of principles, provides examples of how they might be applied, how you might approach certain scenarios. It's not necessarily a one-size-fits-all approach, and each organisation will be slightly different, but it is worth looking at to get you thinking about these issues. So, website and cookies. If you collect personal data via your website, you will need a privacy notice policy. A lot of businesses, most businesses will have these already on their website, but we can of course help you with that if that's something you are needing some assistance with. With regards to cookies, you will probably have seen more and more websites requiring consent to cookies before you can log in or even proceed to look at the website. So you must inform users about them and explain how they work and consent. Why are you using cookies? What are you doing with them? A full cookie policy will be needed. So marketing. GDPR is obviously a concern for marketers who have large databases of personal information that may be tainted, I suppose. If this is a concern, our advice would be to contact the database and seek further consents for what you're doing. Some of you in the room will have been receiving emails from various companies seeking that you reconfirm consent, so it's really just an extension of that. It is worth noting that marketing is based on consent, so individuals are always permitted to object to marketing. There's no exceptions here, such as necessity as above for processing of data. The privacy and electronic communications regulations continue to apply. So these regulations relate to marketing communications made via email, phone, text, etc. Deals with cold call marketing and the restrictions there. So those existing rules will continue to apply, although a new e-privacy directive is actually expected soon, and that will impact that area as well. So that was just principle one, fair, lawful and transparent treatment of data processing, which includes consent. So don't worry, the rest of the explanations aren't quite as long-winded as that, you'll be relieved to hear. So the second data protection principle is purposes. So personal data may only be collected for specified, explicit and legitimate purposes and must not be further processed in a manner which is incompatible with those purposes. So relatively self-explanatory, you will need to let the data subjects know why you're collecting data from them, and you must ensure that that purpose is legitimate. Don't overstretch here. If you've indicated the purpose is X, don't then use the data for purpose Y. This might come into play for marketers who perhaps represent a number of brands within the same group. If the purpose of processing was for brand X, it may not extend to brand Y, even though they're within the same group, so do be as specific as possible. The next principle is adequacy, or sometimes referred to as data minimization. So the personal data must be adequate, relevant, and limited to what is necessary in relation to the purposes for which the data is processed. So, if you're a business delivering an online-only service, do you need to know the individual's home address? Possibly, if necessary for billing or some other necessary part of the service, but consider whether you do actually need the information you're requesting. Takeaway from this, I think, is less is more. Don't overreach and ask for extra information you don't really need. Principle 4 is accuracy. So, personal data must be accurate and kept up to date. Every reasonable step must be taken to ensure that personal data that is inaccurate is either erased or rectified without delay. So you've got to deal with inaccuracies or errors, and retaining or obtaining information that you know is incorrect or inaccurate will not comply with GDPR. Principle 5, retention, sometimes referred to as storage limitation. So personal data must be kept in a form that permits identification of a data subject, i.e. it can be used to identify a person, for no longer than is necessary for the purposes for which the personal data are processed. So, for no longer than is necessary, I think is kind of the key phrase from this principle. There's a note on screen about retaining data for historical, statistical or scientific purposes, but I think that goes beyond the scope of today's discussion. Please note here the right to be forgotten. So this is a phrase that I'm sure some of you will have heard before. There's a Google case on the go at the moment discussing that with regards, I think, someone who's wanting stories about his criminal convictions in the past removed from search results in Google. So that's ongoing in the courts in London at the moment, I believe. But data subjects do have the right of erasure of personal data in some cases sooner than the end of the maximum retention period. Unhelpfully, there's no defined maximum retention period under GDPR. It will simply be only as long as is necessary and subject to what is fair. Slightly circular, but the principle is not to retain longer than you actually need the data and the information. Principle 6, security, or integrity and confidentiality, as it has been referred to. So, personal data must be processed in a manner that ensures appropriate security of that data, including protection against unauthorized or unlawful processing and against accidental loss, destruction or damage using appropriate technical and organizational measures. So, security measures taken should also be appropriate to the harm that might result from unauthorized processing and the nature of data protected. So what I mean by that, if the personal data is a special category of data, sensitive data that Lucy mentioned earlier on, or could conceivably result in a greater harm for that data subject if revealed, then that should be treated with a higher degree of care. So do bear that in mind if you are holding sensitive data. There is a kind of higher standard there. Controllers also should only use processors such as cloud providers, marketing, prevention providers, etc., who implement appropriate security measures. So data controllers have to think about where the data flows. So those are the 6 principles, and beyond the 6 principles, there's an overarching responsibility on data controllers for accountability. So the data controller is responsible and must be able to demonstrate compliance with the data protection principles. So, what are your rights as individuals? Much of the discussion so far has related to handling how you are a data controller or a data processor. What if you're a data subject? So, what rights do you have? You have a right of information. So, data controllers must provide data subjects with fair processing information. So, who the data controller is, the purpose of the processing, details of any proposed transfers of data, maybe to third parties, the retention period, or maybe the criteria used to assess the retention period. You must also inform them of the right to withdraw their consent and the right to lodge a complaint with the ICO. You'll see from what I've said there, a lot of this overlaps to what's contained in the consent, but this is essentially just giving the individuals the right to request all of this information from a data controller. Next up, right of access, SARs, that's subject access requests, again mentioned earlier. These actually exist under the current regime, but I think the profile of them is likely to increase under GDPR. One area where SARs, subject access requests, are routinely used is employees requesting information held by employers, as Lucy mentioned earlier. Any customer can request copies of data held by any data controller, so banks would be obliged to provide you with copies of any information held by them about you. Controllers must respond within 30 days, and there is no cost to the data subject for making the request. Previously, or currently in fact, before GDPR, it's 40 days, and I think you can charge £10 or some nominal fee, but now it's 30 days and no cost to the data subject for making the request. So potentially this could be a nuisance for data controllers, and I think there is a possibility of abuse here. I think data controllers will be concerned about resources required to adhere to any subject access requests made. Responding can be time consuming and costly. I think if there is a positive to this, I think this will encourage data minimization, so less is more, and will also prompt data controllers to go for shorter retention periods. I've heard anecdotally about a school who, after pupils left, deleted information about those pupils other than some basic information. I think a former pupil had made a subject access request, probably just being a bit mischievous, or perhaps for valid reasons, I'm not quite sure. But I think the possibility for abuse by former pupils was a cause for concern for them, so they minimised, got rid of what they didn't need, kept the basics, and then it was much easier to comply if a further subject access requests were to be made. So don't keep what you don't need, and don't keep it for longer than is required. And what you do keep, I would keep in an easily readable format that can be kind of accessed and assessed. So if a subject access request is made from John Smith, you can type in John Smith to your database, this is what we've got from him, and then respond accordingly. So that was the right of access. Right of rectification. So if something's incorrect, a data subject has the right to request that the data is updated. Makes sense. Right to be forgotten, right of erasure, I mentioned that earlier. So this should be done without undue delay. There's upcoming guidance from the Information Commissioner to be released on this topic to expand about the right to be forgotten, and there are cases ongoing in the courts at the moment, so it's very much a kind of evolving area. But the right might not apply if the retention of information is for compliance with a legal obligation or for reasons of public interest or public health. So criminal convictions, for example, you wouldn't necessarily expect the authorities to delete that if someone requested them to do so. Right to restrict processing. So if a data controller has inaccurate information or holds it for too long, then the data subject would be able to request that the processing of that information is restricted. Right to data portability, mentioned earlier as well. So a data subject can take the data held or request the data held and move it elsewhere. So if a data controller is requested, if there is a request for the portability of data made, they have to provide that data in a structured, commonly used format. So you can't kind of provide it in a slapdash way that no one can understand, or in highly technical format. It's got to be in a structured, commonly used and readable format so that anyone can understand that data, and potentially a data subject might want to move that data to another data controller ultimately. Right to object to processing, so I think that's similar to the right to restrict, and right to request automated processing. So the data subject can request that automated processing of data, i.e. without any human involvement in certain circumstances. So I think that's me run through the principles and also rights to the individuals have. So I'll pass you back to Lucy, who will have a look at how you might deal with a data breach.
Thank you. So, data breaches. I don't know if any of you heard last week about what happens with the SQA. Anyone? No? So Friday night, 4 o'clock, we're all thinking GDPR at the moment at Morisons, and I heard in the news that the SQA had to make a report to the ICO. So they sent an email intended for one marker to lots of markers, and I suspect they didn't use the BCC field, and they used the CC field in the email, and so all these email addresses of all these markers across Scotland were shared. So I think they represented that they were only email addresses, and they have apologised, but it just shows you how important it is to take care when you're dealing with personal data. Email addresses can identify you, just like your name, just like your home address, just like your phone number. So it's very important to be aware of these things. They will still need to report it to the ICO, and I think they're in the throes of that just now. But it was very topical, obviously, because today and yesterday we were doing these seminars. So if you suffer a data breach, it is your responsibility to inform your data protection authority. For us here in the UK, it's the ICO. And you've got to do that within 72 hours of your organisation becoming aware of it. It is a very tight deadline, to say the least. You might not know every detail of the breach after discovering it. However, your initial contact with the ICO needs to outline the nature of the data that's been affected, roughly how many people have been impacted, and what the consequence is to them, and what measures you've already actioned and that you plan to action in response. However, before you make that call to the ICO, you need to tell the people that are affected, so you need to inform those data subjects. And those who fail to meet the 72-hour deadline could face a penalty of up to 2% of their annual worldwide revenue, or 10 million euros, whichever is higher. So be aware. The next thing I thought it would be good to know about is privacy by design. So this is all about upfront thinking, and it's considering at the early stages of all work projects, tenders, transactions or contracts, what personal data you need and how you're going to process it, and asking, is it really necessary? The example of the earlier of the companies operating on a global level would definitely benefit from introducing privacy by design into all of their new projects as standards, testing existing projects for possible breach risks, and using the outcomes to help ensure any risk of breach is minimised going forward. Privacy impact assessments. Data protection impact assessments are also known as, help organisations to identify the most effective way to comply with their data protection obligations and to meet individuals' expectations of privacy. And they can be a really integral part of taking a privacy by design approach. They are more relevant to the types of businesses that carry out high-risk processing, so for example systematic and extensive processing activities like profiling, or large-scale processing of special categories of data or personal data relating to criminal convictions or offences, or large-scale systematic monitoring of public areas, so things like CCTV. A couple of wee circles here of some buzzwords. I wanted to talk a little bit more about the ICO and the regulator. We don't think there's cause to panic just yet, but we have heard from Elizabeth Denham that she has indicated publicly that she's tooling up for the job that's been created by GDPR. She has requested a bit more cash to recruit and to train some people up, so I think she's expecting to be busy. The B word, Brexit. The UK government has recognised that it will still be part of the EU this May, so when GDPR comes into effect, and the UK has also stated that it will comply with GDPR, and that compliance will not be affected by Brexit. And to this end, last year the UK Department of Digital, Culture, Media and Sport published a statement of intent in which it outlined the policy and objectives behind the proposed data protection bill. And that was introduced in Parliament in September, and it's making its way through the Houses just now. Fines. So under the current Act, the maximum fine the ICO can levy against a data controller that has breached the legislation is £500,000. Under GDPR, the ICO can impose fines of up to 20 million euros or 4% of group worldwide turnover, whichever is greater. And that's both against the controller and the processor. And not only might there be fines, but you need to be aware that in addition, individuals will have the right to claim compensation for any damage suffered. There could be financial losses associated with reputational damage and breach of trust that could occur, so you need to watch this space. Enforcement orders. So there are a number of tools available to the ICO for taking action to change the behaviour of organisations and individuals that collect, use and keep personal information. Examples of enforcement orders are information notices that require organisations to provide the ICO with specified information, undertakings, committing an organisation to a particular course of action to improve its compliance, enforcement notices and stop-now orders, where there has been a breach requiring organisations to take specified steps to ensure they comply. There's consensual assessments or audits to check that organisations are complying. There's assessment notices to conduct compulsory audits to assess whether organisations are following good practice. And there's also monetary penalty notices requiring organisations at the moment to pay up to 500,000, but later the larger fine. And then there's prosecution possibilities, and there's also reporting to Parliament on issues of concern. We have heard on a number of occasions that Elizabeth Denham is less keen on financial penalties and prefers to issue enforcement orders. And I thought it might be quite helpful to have a couple of examples of where these enforcement orders have been used. So last year, an example of an ICO enforcement was with a Liverpool company called the Lead Experts Limited. They made 111,072 automated marketing calls to subscribers who had not given their consent. No consent, no contact details for the company provided, big trouble. The firm said it had bought people's contact details from another company and then paid that company to carry out the calls, which were about reducing energy bills apparently. But the ICO investigation found that the lead experts were responsible for ensuring that they had the necessary consent to make the calls. So they were fined £70,000 last year. And coming back to the ICO head of enforcement, he's got lots to say. He said companies cannot hide behind paying another firm to make the calls for them. They must take responsibility and ultimately accept the consequences if they break the law. And another example, more recently reported just last month in February, a company made 8.7 million nuisance calls and was fined £300,000 by the ICO. Homes Financial Solutions Limited, again based in Liverpool, made the automated marketing calls between 2015 and 2016. The 8.792907 calls contained recorded messages primarily promoting PPI compensation claims, but the company did not have the recipient's consent for sending direct marketing, and that's against the law. The ICO received lots of complaints from the public, and they said that the company paid no heed to laws on telephone marketing and showed no concern for the distress they were causing people by making this huge volume of invasive calls. And the ICO will not tolerate this. Finally, security. So recent research by Imperva in a snap survey of IT security professionals found that whilst the overwhelming majority of them are aware of GDPR, just under half of them are preparing for its arrival. So just 43% are assessing GDPR's impact on their company and changing their practices to stay in step with data protection legislation. Our advice is to engage with your company or your business's IT advisors as soon as possible, whether they're in-house, whether they're external, and give GDPR the serious consideration it is due. Stephen's going to just talk us quickly through what you guys need to do now.
Absolutely, thank you very much. So, what to do now? I think the first thing, review the documents that you have. So, privacy policy, cookie policies, any other documents or online forms you have which relate to data. Review your procedures, review data security, and ensure ongoing compliance. So, I think essentially what we would recommend you do is carry out what might be referred to as a data audit of data within your organisation to help you identify the personal data you hold and what the processing activities are. So I think the things to consider here are whose data you hold, what is the data you hold, what data do you actually need, how did you obtain it, how do you process it, what do you actually do with the data, and where does it go within your organisation? Does it actually flow out of your organisation to third parties? And how long do you retain it for, and where is it stored? So I think kind of simplistically, maybe a kind of who, what, where, when, why, and how of data is a good way to look at it. I think once you've done that basic who, what, where, when, why, and how data audit, that should help you identify if there's any gaps within your systems and help reveal any issues you may need to address. and try and work out what the solutions or improvements might be. I think thereafter you need to implement an action plan of what are you going to do and how are you going to do it. It might involve updating your documents and procedures, maybe even involving going back for consent from some data subjects. And I mentioned the Wetherspoon's example before, going through a process of data minimization. So if, for example, you've got data from an individual in your database from, say, 2 years ago, you haven't contacted them or haven't had any reason to hold that data, you might actually consider deleting it. Or the alternative might be approaching them for consent to retain that data. But if you were to do that, you'd need to let them know what you're doing with that data, and again, they're informed of specific consent. So you would need to be quite specific about going back to them. You couldn't just, there would have to be a reason for you approaching them to seek their consent again. Part of the implementation phase would be staff training, bringing your staff up to speed as to what you're doing. And then you've got ongoing compliance, so ongoing monitoring of procedures, training managers and staff to get them up to speed, and going through the ongoing compliance part, privacy impact assessments. Lucy mentioned them earlier. There's actually a code of practice contained on the ICO website, which I'll repeat again, ico.gov.uk. They're not mandatory, but set out a best practice framework of how you deal with privacy in your organisation. So they're an aspect of ongoing compliance. So if you're about to carry out a new function within your business or change the way you do certain things, we would advise you carry out a privacy impact assessment to see what impact your proposal will have on privacy. And there is a lot of guidance on the ICO website, as I've said. Compliance with GDPR is an ongoing obligation, and it is the overall intention to be a structure of privacy by design, not privacy as an afterthought. So any areas where you're using personal data, you need to be thinking about these things, and the who, what, where, when, why, and how, I think, can be a useful way of thinking about it. And I will pass it back to Lucy.
So that brings us almost to the end, you'll be relieved to hear. So it's not all doom and gloom. We don't believe, and we do think that there's light at the end of the GDPR tunnel. Organisations that are keen to comply do need to engage their teams, as Stephen said, and make sure that it's done correctly. And we believe that additional benefits can be gained by businesses. For example, commercial performance can be driven through higher quality and more accurate data, potentially. And you can get a greater insight into customer needs, leading to improved customer satisfaction, potentially too. Some feel that GDPR is a reflection of a growing value being placed on transparency and authenticity. Consumers, you and I, know the value of our personal data, and we want to control how it is used. Some are even going so far as predicting a new generation of brand loyalty based on trust. So as advisors in this space, we look forward to helping our existing clients and new clients come on board to turn GDPR into a slightly more positive experience. You can get lots of advice online. As Stephen said, the ICO website is great. And we'd also like to help you if you need the support. These are the types of things on the slide that we can help you with. Stephen's already mentioned a few of them, but I thought it might be quite good to summarise them. Data breach reporting, you might need some help with that. Data processor contracts, you may already have some in place that might not be GDPR compliant. We've already reviewed some clients' contracts and made them GDPR compliant, so that's in advance of May, which needs to be done. And yeah, so if you get any questions, then these are our contact details. So I'm Lucy Gannon, one of the partners here, and Stephen Clark is one of the senior associates in the corporate team, and we would be happy to help you with any of your GDPR challenges, for want of a better word. So feel free to contact us, give us a buzz, or ping us an email, and that ends the workshop today. So thank you for joining us. Thanks everyone on the webinar as well.